Okay, I'm here to talk to you about Child Protective Services and how they handle abuse cases that I think you should know about. Number one, do not take your child to the ER. Why? Your child could be in a room and they're going to ask you to leave, and 5, 6 adults go in there, including a police officer, and say things and ask your child things that you don't know what is being said or heard. So they could put words in the kid's mouth too, and you don't even know what's going on. Don't do it. I would speak with an attorney first. I would call an attorney. Most people don't think about this because they can't afford an attorney. I say find one, at least to get information on what you should do. Child Protective Services has their own investigation team where they have doctors and psychiatrists available for the child. So you don't need to take the child to the ER. Another thing is they don't reopen a case. They do not reinvestigate. You take your child in when it's still early and you don't know enough about the case and you're scaring the crap out of the child's not going to open up. Therefore, the child is not going to be taken seriously. The child is the state's only witness, and they will not reinvestigate the case if the child doesn't come out the first time and tell them exactly what went on. If the child hides any information, doesn't want to come forward with any information, they will not reinvestigate later. If the child comes out with a therapist and tells the therapist what really did happen, even the therapist making the report to Child Protective Services, CPS will not reopen the case. Another thing is they ask the father or the abuser, whoever it may be, did you abuse the child? What do they think? The abuser's going to say yes? Really? So I just find that quite absurd. And another thing is they discourage you from recording your child's abuse accusations. You don't know what's legal and not. I not only had Child Protection Service team tell me that I should not record my child, but I also had the opposing party's attorney, before I hired my attorney, tell me that I should not be recording the child. That's right. You cannot act on behalf of the child either. Even though you're the legal guardian, you cannot act on behalf of the child in a hearing. You have to hire a guardian ad litem, which is basically an attorney for the child when the state cannot bring charges, in order to protect your child from this person. Or ask for a social investigation during your paternity custody petition. And this costs thousands of dollars on top of the attorney that you have to hire for the paternity custody time-sharing action. So I hope you found this useful, and I will be making more videos soon. Take care.